again to another episode of Tally Stakes, and we are very happy that you are here with us tonight. We want to show our appreciation to our viewers who have been liking and commenting and sharing the videos. Please continue to do same. If you're watching this video and you have not yet subscribed, please remember to subscribe so that we can get this video out to as many persons as possible. We want to equip people with varying perspective, building their characters, because we believe that stronger people results in stronger communities. Stronger communities will result in stronger nations, and stronger nations will result in a stronger world. All right. So again, thanks for joining the conversation. Thanks for being with us. We appreciate you. And as we delve into an exciting topic tonight, we hope that you'll be learning something new and something with which you will be able to take away and make better decisions. So tonight, we'll be talking about jarring judges. Let me just put a disclaimer here, because I want people to understand that I have a very strong view on justice and judiciary. All right? Very, very strong view. And so I want you to bear that in mind as you watch the video. Also bearing in mind that these views are mine, but I also accept and appreciate that there are other perspectives, people with other experiences, and I respect those. But I just want people to understand that these are my views as it pertaining to the judiciary and judges. All right? One of the things I want people to understand, as is happening now in the United States, we have some federal judges who are usurping the authority of the executive branch. And my concern, it brings to focus again, my concern that I've held for many years, that I just believe that the judiciary goes unfettered and goes unchecked. I think it is the most powerful branch, despite what other people might believe, and I think that it needs some more checks and balances where it comes to the judiciary. I cannot, for the life of me, cannot understand why a judge would usurp the authority of the president and to decide on questions of broad federal policy instead of ruling on discrete matters. This is discussed in the panel with Scott Jennings. Scott Jennings is a conservative commentator on CNN, and Scott Jennings is going to is going to discuss with us the implications or the situations of these judges' rulings. But bear in mind, for those who are understanding or those who appreciate what is happening in America, sometimes and in some other instances, there are some similarities that happen in other countries. And of course, I'm going to be looking at a similarity of an incident that I believe that the judges were outside of their remit. And the decision, they made their decision, but I believe that it's really ridiculous. And it just brings the question, how is it that we can get these judges accountable? How we can let them understand that they too must succumb to the will of the people? Countries are governed and ruled by will of the people and not the will of a small set, right? So here we have the situation now that is obtaining in America as it relates to those federal judges who are trying to usurp Donald Trump's executive orders. And Scott Jennings is discussing this issue with Abby and the panel on CNN. All right, so listen as we delve deeper into the discussion, and thereafter I will return with my views and other information as I will further explain the role of the branches of government, the executive branch, which is the head of state, in some countries the president, in my country it's the governor general, and in that branch as well, the prime minister exercises most of the authority of the executive with his cabinet. In America, the president and his cabinet members also exercises the authority of the executive. And then you have the legislative branch. The legislative branch is the branch of government that makes laws. And so we refer, as in my country, the parliament, and in US, the Congress. In some other countries, they're called the assembly. All right? And then we have the judiciary, which is the judges and the courts that exercise the authority of the judiciary. And in the judiciary, the Supreme Court is the final stop. And I am suggesting that as it is now in our context, in almost every country, that we have an unchecked Supreme Court that can make rulings that could just be deranged. And in some instances, well, in some instances in America, there are some kind of checks and balances where we can remove those judges. But removing those judges that do not necessarily mean that we can change the ruling unless another matter is brought before the court, and then the court may rule and overturn a previous ruling. So again, we need to put some checks and balances in place to contain these judges. So let's listen to the situation now as it obtains in America.
But we do know that judges do get to say whether the executive is complying with the law or not. That's been the case for decades, hundreds of years.
Well, I think there's a difference between saying whether you're complying with the law and then you have these individual district court judges setting effectively broad federal policy that is specifically reserved for the president of the United States. I think we do have a constitutional crisis, and it's being caused by these judges. They're not here to tell us. They're not here to tell us how to spend the money. They're not here to set broad federal policy. That is the president's job as elected by the people. These judges are supposed to be settling discrete, specific matters, not policy setting. I think Vance is right. I think Trump has a point. And these judges want nothing more to continue the lawfare against
I don't
Trump.
think anybody's going to be surprised to hear that you think.
So what should happen if a judge is setting policy? A judge cannot set policy, right, in government. That job is reserved for the executive. The executive set policies. The courts rule on issues that have been brought to them. So, for example, a citizen, as in Donald Trump's case, let us say a transgender person who would not get access to funding because Donald Trump now made a broad policy that the federal government will not support access to certain types of funding, like funding to transform children into other sex. All right, I think they call them I don't even remember what they call them, but that sort of surgery where they change the sex of the child. Now Donald Trump says the federal government will no longer be in charge of that. All right. Now a citizen, say a citizen John Brown, goes to the court and say, I think that this action that the government has taken is impeding my constitutional right, or it puts me at a disadvantage, or whatever, and my rights have been abridged. The court now is to look into the matter of how this person, John Brown, was affected and have been hurt by the policy. Now, in determining how the person has been hurt, the court may rule that the policy is unconstitutional because it would know the way how it affected John Brown, it may also affect all other persons who would be easily fall in the same situation as John Brown. But what we have is a federal judge who has said, you are to stop your policy until I consider the issue of how John Brown has been hurt by the policy that you have put in place. And this is unconstitutional because in essence, when the court says that you are to stop your federal policy, the court is now making a decision of broad policy without a ruling of how John Brown's matter has been hurt by, or how John Brown has been affected by the implementation of this policy. So what they do, they go to certain judges who have similar inkling in political beliefs. And so in essence, what the judge wants to do then is to overturn an executive policy without having done any ruling on any case, because somebody might say, no, the judge is saying you have to hold on to that. You cannot implement this policy because as implemented, it may be unconstitutional, but you did not rule that it was unconstitutional. So therefore, you cannot stop or imply or cause the policy from being implemented. This is outrageous. There's another situation where judges were telling them in the State Department that they were to change the language and restore the language of the previous government. And how is it that they are giving that instruction? Who came to them and said that the language on the website was a grievous to me and it was a breach of my right? You tell me now. This is completely unacceptable. So we have now judges sitting on their benches and they are making federal policy. And federal policy is reserved for the executive because the judiciary is to interpret the law and then to indicate whether or not the other branches of government were outside of the remit or the ambit of the Constitution.
Yeah, but
Trump is
they're
right
doing
again.
this on
However,
purpose. Just on a real important technical point here, one of the main disputes is whether the executive branch can just decide not to spend money that another co-equal branch has said ought to be spent. So it's not just about forcing the federal government to spend money. It's saying Congress said you need to spend this money this way, and the executive branch saying, no, I don't feel like it, and the courts say you have to
Well, my
comply with
answer to
the
that simply is it is the executive branch's job to figure out how to spend money once it is appropriated by Congress. And sometimes they spend money that's not been appropriated. But the correct political control is between the executive and the Congress, not some random
I want to
federal
return
judge.
to that
really
because
think-
that is also a major legal question. But
Do you
go ahead.
really think that J.D. Vance's tweet is only about these district judges?
I think
this is
yes.
about no. This is a slippery
it's the first-
slope
it's the first
because
piece.
they're going to move on to what the next ruling is. They're setting the stage so that they can say that executive branch has control now over the judicial branch. They're setting the stage.
And Gretchen Carlson is very disingenuous because Gretchen Carlson knows that these judges have been shocked. They are specifically identified by these Democrats who are bringing these cases to them because they share similar political views, and that what J.D. Vance is saying, that if the judge is going to usurp the authority of the president, then these judges ought to be ignored. Obviously. But what is happening? If you ignore them, you're in breach of the law. So who corrects the judge? Another judge? No, man. We as people, hear me now. We as people, and this situation don't only occur in America. We as people must demand of our legislators and those who frame and guide the constitutions in our varying jurisdictions that we do not want one branch of government to be so powerful, and we do not want the judiciary to be supervising the judiciary, because the only way this judge now is going to be corrected is when it goes to the Supreme Court, and the Supreme Court is a part of the judicial branch. This doesn't make any sense. So if the judiciary is in conflict with another branch of government, it is the judiciary who must resolve the conflict. This is complete madness. And everybody's going on like this is okay. This is complete madness.
For people who
disagree.
think that President Trump has not planned all of this, he pushes the envelope constantly. There was January 6th. He has a myriad of people out there that would support the executive branch being able to rule over the judicial branch because there have been no repercussions. And when there are not consequences and when there are not repercussions, you get away with it.
I get it. You want individual federal judges who hate Donald Trump
No, I don't.
to tie him up for 4 years.
No, I don't.
If you want a big
Not at
policy
all.
question,
And this is a part of the strategy that they're using. Put a restraining order on Donald Trump, because Donald Trump won on a particular agenda. And on this agenda, he now is implementing this agenda. But if he is restrained by the courts to implement his agenda, until the matter has been resolved in the courts, which may take 2 to 3 years or even 4 years, by the time the matter is resolved, Mr. Trump's term would have ended. And therefore, the same thing that they did not want to be implemented would not have been implemented. And what they would have done would have gone through the judiciary to actually halt the executive from doing its job. And everybody's going on and pretending as this is okay. I don't know if I am the only one who thinks this is complete madness. This is not tenable, and we definitely need to look at the judiciary branch of government.
questions decided let the Supreme Court do it. But in the interim, the executive has to be allowed to
Pray
govern.
tell, how do we get to the Supreme Court? Can
Just
somebody
appeal,
tell me?
and that's fine. But you can't tie them up
we get
until
to
it
the
gets
Supreme
there. You
Court.
can't tie them up
We get
until
to
it
the
gets
Supreme
there.
Court by the judge's ruling, things going to appeal, and then it goes.
And in the
up-
meantime, what happens? Trump can't act?
In
Trump can't
the
act?
meantime, you're supposed to comply with the court's rulings. Am I wrong about that?
Well, you're supposed to comply, but Scott's absolutely right in that the court cannot say you have to spend these dollars today. So as a governor, I dealt with this. We got things challenged in state court and federal court. It's all judge shopped, by the way. Judges don't randomly get these cases. There's a reason that these cases are filed in Boston, the Boston court, or a certain
Island.
district, Rhode Island, because they know they're going to get a judge that
That's
is
a
politically
great
favorable.
bipartisan practice as well.
Yeah. Oh, both sides do it. I mean,
How
I
many-
think
how many times that district court and judge one guy in Texas shut down Joe Biden?
But you raised the right point. Should the president,
the
the
Biden
singular
administration
president,
actually
should he have to
went
share
along with what the
should
judge
he
said.
have to share the presidency with 300 district court judges?
Absolutely
No,
not.
absolutely
But
not.
but the point, though, you made a really good point that there have been judges that shut down some of President Biden's executive actions, and they understand, the Biden administration understood
And he
the
ignored it.
checks and balances.
The Supreme
But
Court
not-
tried to stop me,
not
but they
in
never will.
But not
Who
in the
said
way
that?
that Donald
Who said
Trump
that?
is.
Who said
Not in
that?
the way
Yeah,
that
Joe
Donald
Biden.
Yeah,
Joe
but,
Biden.
Donald Trump
Scott,
is-
he actually didn't ignore it.
He
That's
did.
right.
They continue to plow
no.
forward with
No,
student
he
aid. How
didn't.
much did
No,
they spend?
no, no.
Let me set the record
He
straight.
actually got dinged
did
on
he
the
say?
student
I
loan
hated
debt
the
forgiveness.
Yeah.
student loan forgiveness
What
policy.
did he say
Hold
out
on.
loud?
I thought
What
it
did he
was.
say
I
out
thought it
loud?
was a ridiculous
didn't
policy.
ignore it.
I thought it was unconstitutional. I predicted it would get struck down. It did get struck down, and I
didn't
applauded.
ignore it?
He did not ignore it, though. He went and tried under a different law.
So he ignored
You're
it.
allowed. No,
That's
that's
not ignoring it. That
So
is
you were-
trying
it's not
to
ignoring
make
it.
it
It's
work
trying to
under
do it.
law.
He's
He
trying to do
literally
it.
defied it.
But let me just understand where you stand. If a district court judge rules in a way that the president dislikes, should the president listen or should the president defy?
If a district court judge tries to usurp the authority of the chief executive of this country, he should absolutely defy it. There's a difference between broad policy decisions and discrete disputes between parties. That's the difference. If I want a policy decided, I'll take it to the
But what
Supreme
about checks
Court.
and balances?
Well, Scott, you're
What
also
about
of a
checks and
district
balances?
court judge?
What I
Who
can't
elected
what I
them?
can't get with is you talking in these bizarre, broad generalities.
It's not bizarre.
Every single one of these cases deals with a discrete issue. Okay, it deals with funding. It deals with with certain constitutionally or statutorily appointed roles. Every single one of these things is a distinct thing, and they're all being dealt with by different judges. So it's not broad swaths of policy here. When the
is.
court says, Congress, appropriated this money, you must unfreeze it while we litigate this. Why can't Trump comply with that?
So you're saying that a judge should decide how and when money is spent
judge is saying-
for years and not the president of the
Look,
United
Scott,
States?
let me explain
You're a governor,
little
you
bit more.
know.
Let me explain it a little bit more slowly. A judge is saying
You don't have to talk to me like that.
Congress.
I have a position on this, and you have an
Okay.
opinion. We can disagree.
Yeah, but I'm saying you listen to me because you're not listening and you're making claims that are not connected to the facts. The judge is saying
Maybe you are.
Congress appropriated a certain amount of money.
Yeah.
We need to litigate this.
Okay.
While we litigate this, we're going to put a hold on the actions that you took that might be unconstitutional.
So while we
That's
litigate-
part of the
while we
process.
litigate
Why-
So if the actions might be unconstitutional, the actions could also be constitutional. So why should he stop? Why not rule on your matter, and when you have determined whether the action is unconstitutional or not, then we can now address it. Why would you want to stop the executive from implementing the policy which they are in their well right so to do? This does not make any sense. And everyone smells the rat.
I
If
can't.
I'm
Why
a
doesn't
judge
that
and
work?
I'm in charge of the executive branch and you're not, forget it.
You
I totally
just
disagree.
can't compel the executive branch to spend the dollars. You can't do that. They
Okay.
can't say we're going to start. The
Have
judges
you
are going to
heard
start
of
writing
the
the checks. They have every right
impoundment?
to
Have you
hold
heard
that.
of the Impoundment Control Act of 1974?
No.
Okay, well let me play this. let me play
And by the way,
this.
none of your viewers have
Okay,
either.
well I'm gonna
I can explain it in a
I'm gonna
sentence.
play this clip for you. This is
Now, again, still, whether the Impoundment Act, so the Impoundment Act talks about that the executive should spend money that the Congress has allocated. But bear in mind in this instance that the executive has not decided not to spend the money. The executive has decided to put a freeze on spending until they have conducted their investigations into fraud, waste, and abuse. The court cannot say you cannot freeze the money. That doesn't make any sense. Absolute craziness. This, again, is another Absolute craziness. Absolute craziness. Now, let me now show you of a situation now in Jamaica where the court ruled, and it's a very popular case here in Jamaica. So there's a particular DJ and his co appellants who made an appeal to the Court of Appeal and then to the Privy Council that their convictions were unconstitutional because their rights to a fair trial was breached when the juror who was corrupted was allowed to be a part of the deliberations. And they contend that because this person was there and approached the other jurors, then the other jurors may have voted guilty, because if this one juror was paid to bribe us, then it must mean that the accused is guilty. So the judge's failure from disbanding the jury was a question of the appeal, and his failure to do so prejudiced the trial against the appellants. So the matter was brought first to the Court of Appeal. The Court of Appeal dismissed the appeal. The appellants, or the accused, went to the Privy Council, which is the final Court of Appeals in Jamaica. The court ruled that the case has to be quashed because the presence of the juror prejudiced the accused from getting a fair hearing. And so what the Privy Council decided was to remit the case to the Court of Appeal for their determination of whether there should have been a retrial. All right. So if you are saying that the jury was corrupted by the actions of one, and the action of one, because he bribed the others, caused the others to believe, then the accused, if the accused is prepared to go to this extent to prevent a conviction, then truly the accused must be guilty. All right, so that jury is corrupted, because then now they are not only have to rule on the facts of the case, but they are now seeing this behavior, this wayward behavior of the juror, and may now surmise that the accused really is guilty. So the jury should have been disbanded. The judge did not disband the jury and then request a retrial, which again I think was what they're saying that the judge should have done. Now, when the case was remitted to the appeals court for them to determine whether there should be a retrial or the accused should be set free, the court ruled, I don't even understand the ruling, because the ruling is pure garbage. Pure garbage. It is the darkest day in this country, and there is no appeal or no supervision of judges. And we are just a go on and a go on and a go on and a go on and think this is okay. Disgraceful ruling. The court ruled that, yes, they understand that the case was serious, right? And I'm going to skip out the part where they give a summary of what I just did, all right? So they are now going to determine, after having listened to the submissions from the counsel of the accused or the convicted, and then the representative from the department, from the director of public prosecutions department, they are now looking at 12 main factors, and I'm going to read some aspects of the ruling that was submitted or published to the press to explain their ridiculous and absolute outrageous ruling. Other people in the law firm believe this, in the law fraternity believe that, oh, it's an excellent ruling. How is it that just the judiciary is not preoccupied with expending justice for its citizens? They are very much more concerned about executing rules that they have created, precedents that they have set. And justice is at the back of everything. Justice is the last thing. Justice, when, in my mind, when justice is in a courtroom, justice, the hands are just around the neck of justice. and poor justice can barely survive because they have to go through this law and this precedent and the rule of law and whether this did go this and this did go this and all sort of garbage. Because how is it if the judge made an error, as you have maintained, that the judge made an error and that the jury should have been disbanded, right? There is no law in our country that allows judges to disband jury and then rule on the case, right? In our jurisdiction, the judge would have to rule a mistrial, and so everything would have to be redone. And as you can imagine, a trial of this nature is very expensive and requires a lot of strategic implementation of a relationship between variables to maintain good security to properly try the case. So here we have the judges from the Court of Appeal ruling. Based on these principles and the submissions of counsel for the appellants and the Crown, the court has considered 12 main factors in its determination of whether the interests of justice require the appellants to face a new trial. The nature, seriousness, and prevalence of the offense. The strength of the prosecution's case. The availability of the prosecution's witnesses and trial exhibits. The availability of defense witnesses and any evidence which tended to support their defense at the first trial. The issue of delay and whether a new trial can be facilitated within a reasonable time. The time, financial costs, expense, and impact of the court's resources that a new trial would have. The ordeal to be faced by the appellants if a new trial is ordered. The impact of prejudicial publicity on the fairness of a new trial if one is ordered. Whether a new trial would give the prosecution an unfair advantage. Changes in the Jury Act and potential legislative changes in the sentence for murder. The possibility of prejudice arising from the mandatory minimum. This is just complete rubbish. This is just complete rubbish. What do you mean the possibility of the prejudice arising from the mandatory minimum sentence and minimum term before eligibility for parole under the Offences Against the Person Act? That cannot be a consideration. This cannot be real. This cannot be real. And the interferences and likely interferences with the appellant's constitutional rights. So these are the 12 factors. The court has considered all the factors governing the court's determination of whether a new trial should be ordered and has given due regard to all the material submissions and evidence presented by the appellants and the Crown. And the Crown, in our context, would be the people. The American would refer to them. The egregious nature and seriousness of the offense in this case is beyond argument. So too is the prevalence of the offense of murder in Jamaica. Okay. The feature of this case bear every hallmark of a deliberate attack on and barefaced defiance of law and order involving allegations of transactions relating to illegal firearms and alleged killing in respect of which the body of deceased has not been recovered, and interference with a crime scene while it was under the control of the police. The court is therefore satisfied that the nature, seriousness, and prevalence of the alleged offense in this case are powerful factors that weigh in favor of ordering a new trial. This is the rule, this is the opinion of the court. This is the opinion of the court. All right. Let's go on. It gets even more interesting. The court is also satisfied that even though the prosecution's case was based substantially on circumstantial evidence, the prosecution had presented sufficient evidence at the trial in the Supreme Court to make out a prima facie case for murder against the appellants. The strength of the prosecution's evidence at the time of the trial in the Supreme Court is also a factor that would weigh in favor of ordering a new trial. So the evidence is good, right? The offense is dangerous. Let's move on. The court, however, finds that there are several equally powerful countervailing factors declaring a new trial. In summary, these are the inadequate account by the prosecution for the availability of its witnesses and trial exhibits. We confuse. Then make the thing go a trial, and if they don't bring the witnesses and stuff, then they lose. Are we not in the pursuit of justice? I tell you, man, I think, you see, I think that our legislative branch have ceded far too much authority to the judiciary. And it needs to stop. 2. Witnesses and trial exhibits relied upon the appellants, which tended to support their defense at their first trial, are now unavailable, cannot be accounted for. Don't tell me any garbage. What? So what? So what? How did find the witnesses them in the first place? And they are not available. Now, whose fault is that? The appellant's trial in the Supreme Court was complex, lasting 64 days, and utilized a significant share of the court and the appellant's resources. Therefore, the time, financial costs, expense, and impact on the court and the appellant's resources which a new trial will require, and the impact which this case will have in delaying the completion of other cases which are pending in the Supreme Court is likely to be significant. So, hold on. So if a crime commit yesterday and one commit today, we might not be able to try the crime or commit today because there was a backlog of cases in the court from the day before yesterday and yesterday. What you tell me? What you tell me? So we have to now put out a limit on the amount of crime that is to be committed so that it will be sufficiently be able to be tried in the courts using the available resources. Build a new court. Are we not in the pursuit of justice? I cannot believe this. Listen to this. And then now they're going to talk about the appellant's resources. And people entitled to representation and support in trial at the expense of the state. Anyway, listen to this madness. The psychological, financial, and medical effort that a new trial will likely have on the appellant. I can't read this garbage. So what about the psychological impact on the victim's family and all those people who have been affected by this crime? I cannot understand this. Right? They have already spent 13 years in custody, which is demonstrated by medical and other affidavit evidence is likely to be significant. In particular, the court notes the serious medical issues faced by the appellant Lala, which were brought to the court's attention through unchallenged medical reports that speak to his decline in health in the penal system. Oh, I can't do this. The unjustifiable interference with the appellant's constitutional rights to a fair hearing within a reasonable time under Section 61 of the Constitution, and the possibility that that interference will continue if a new trial is ordered. So, if a judge or anybody in the prosecutorial office makes any mistake, that's the death of justice, you know. You hear what I tell you? So you who have your death in your family, the people who die for you, justice hangs upon the conduct and the competence and knowledge of your prosecutor, your police, and all those other arms of state. Because if once a mistake is made, and as in this case, he needs to have a speedy trial. He had a speedy trial. You said it was a mistake. So it's not that he didn't have a... What is this? Then listen to this nonsense. The potential prejudice to at least 2 of the appellants who, if convicted after a new trial, would be required to serve a longer term of imprisonment before eligibility. I cannot believe this. This is absolutely ridiculous. So listen to this nonsense now. Having weighed all the relevant considerations in the balance, the court concludes that the interests of justice do not require that a new trial be ordered for the appellants. And that is it. What is justice? Justice is rewarding somebody almost equally for the damage that they would have caused. You tell me how this is justice. And see, once they have ruled now, guess what? It is set in stone. There is no correction. There is no injunction. There is nobody to put an order on them to prevent them from ruling in this rubbish. And all the country and everybody say it is okay. It is the ruling of the court. And you think that is okay? Well, we are going to go to hell in a basket if we think this is okay. This cannot be okay. We need to return our focus on justice. We need to return our focus on justice. And that is what we need to do. We cannot allow these other rules, these other laws to strangle justice. Constitutional right, consideration of resources and availability of witness for the appellant and all this other garbage that we think that is okay. You now look at all these mitigating factors and you tell me if these mitigating factors are the same as the prevalence of murder in this country, and also whether the evidence is sufficient. You tell me if that makes sense. You tell me if that makes sense. But then, that is the law of the land. Ladies and gentlemen, tell me what you think. I maintain my position on this matter. It is my fervent belief that we have come to a time where we need to review the roles and place of judges and rulings of courts. We need to put in place a way when we are aggrieved by the ruling of the court. How is it whether we have a ruling of the people, a vote of the people, or whether we have the parliament in some special session review the ruling of the courts, or whether the executive is able to appoint impartial bodies to examine the ruling of the courts to see if the court's ruling was actually in accordance with the law and in the interest of justice. But it is my humble opinion that we cannot continue this way. Tell me what you think. Tell me what are your thoughts. Remember to comment, share, like, and to subscribe to our channel as we put out the information to empower people to make the right decisions. Tally is out.